The date of the special meeting must be set within 10 days of the receipt of the removal petition, and the special meeting must be held within 45 days of the receipt of the removal petition. We were kind of not quite sure about this one, but 10 days is not sufficient because when a petition comes in, it has to be checked to make sure that it was filed within the requirements of state law, and that can take 10 days, especially if you're having to check signatures. So this is something we were still discussing, and again, with 45 days of receipt of the removal petition, we have to notify people of the special meeting no more than 60 days and no less than 10 days. So you have to be able to post and get it out in within the 45 days, and sometimes it requires 60 days to get things mailed.
Well, and it must have made it vulnerable because
Yes.
because if you say that you're removed and you don't have an election that we're in line where you put them in there, but you also have to have an independent auditor that takes in the ballots and everything. So I don't think the 10 to 45 days, depending on when you hold the special meeting, if you can even find an auditor to be able to just drop everything and run the election.
Right, and I understand the concern with this because I was involved in the special meeting petition last year and in February. And they, again, have happened so seldom that to make it more cumbersome on something that happens so seldom is just bogging down our bylaws. So this one requires maybe clarification, but not totally changed. We get down to G. The first runner-up in each annual election of the Board of Directors will serve as a non-voting alternate for a one-year term till the next annual election of Board Directors in a non-voting capacity. Again, we've already discussed that, and that is what we are not recommending because the alternate becomes a director, and that has to be changed also in the declaration. They also wanted to add the non-voting alternate were required to attend regular and special board meetings, will not be allowed to attend executive sessions at the will of the Board of Directors, and the non-voting alternate will be required to abide by the Directors' Code of Ethics. Vacancy in the Board of Directors and change caused by a resignation, death, or incapacity of the former director at a time other than at the annual election cycle, should be in there, may only be filled by the non-voting alternate who will serve out the term of the former director. The non-voting alternate will assume the duties of the former member of the Board of Directors, and they have removed affirmative vote of the remaining members of the Board of Directors if the vacancy was caused by resignation, death, or incapacity. In case of a second vacancy, the election committee shall call a special election. Special elections are expensive. If you lost 2 people, you would be paying $3,000 a shot to have a special election. It gets expensive. The law gives the Board of Directors the right to appoint directors to fill out the remaining of the term. It depends on how the bylaws are written. And again, the alternate is not something that fits within our current governing documents. Okay, then we go through. By the way, I want to thank the committee because they did a wonderful job presenting all of this. Garland?
On the removal of a board member, to me, you're reading that, but it doesn't give any guidelines as to why the board would have the power to remove a sitting member that was elected in. And we were talking about when they removed Tony Sullivan last year, and to me that was more of a personality conflict than it was legitimate. To me, the board member has, if he's not following his oath of office and he's being detrimental to the financial process of the fort, then, and he has done nothing wrong illegally, then he shouldn't be removed just because you've got a personality conflict on the board. And the way that bylaws are being read right now, it doesn't cover that.
Does not, the state law does cover it. State law says that the Board of Directors may remove a board member, fellow director.
But I think in our bylaws it should, I know the state law says that you can remove a thing, but to me, you should have grounds and not personality conflicts.
Right. You can, it does say it in here that after 3 unexcused absences, the board member can be removed. We can remove him, we can remove a board member for violation of the code of ethics. Again, the problem being that you have to have directors that actually follow the written bylaws. We're trying to take the emotional response out of this and make it practical to as many conditions as possible. Be aware that we probably are never going to anticipate everything that can happen. We certainly didn't anticipate this last one. And the bylaws committee's been very helpful in trying to anticipate things.
Well,
Okay,
yeah.
but, I mean, we'll take that under consideration to comment about removing, all it says is that the law says that the board of directors may remove one or more directors.
To me, in the code of ethics, if the board member is doing his job and hasn't violated any rules or regulations of the fort, then he should never be removed.
Well, I understand what you're saying. Again, that was, for one thing, Dan did resign. And for the second thing, the petition that was filed to get rid of him was not a valid legal petition. So,
And I'm saying it's all personal.
right. And I agree with you, that's the problem, but the personality, we're trying to remove the personality issues. Okay, we're going to page 14. They added Article 7, Parliamentary Authority. The rules contained in the current edition of Robert's Rules of Order, newly revised, shall govern the association in all cases to which they're applicable and in which they are not inconsistent with these bylaws. Any special rules of order the association may adopt. Robert's Rules of Order themselves say that Robert's Rules of Order do not have to be used in small group meetings. We are a small group meeting. We try to follow what Myrna used to call, those of you that remember Myrna, Robert's Rules Light. Because of our small group. We agreed that going by a strict use of Robert's Rules of Order does not add anything to our meetings, nor does it take anything away if we don't use them, but it could possibly intimidate people who want to run for the board but don't want to have to worry about Robert's Rules of Order. So we agreed that that was an unnecessary addition. The board of directors at any time right now have the ability to basically set up the way they will run a meeting as long as it does not violate state law or any of our governing documents. Again, emotional issue because that happened and we're trying to, Roberts would not have fixed that. Okay, article, that would change to a new Article 9, amendments to the bylaws. Okay, bylaws may be amended, and this is removed, at any regular meeting of the board of directors by a majority vote of the directors, the proposed amendment having been submitted in writing, added to, and this is new, by the majority vote of the membership during an annual election. However, amendments to reflect changes in Title II, Chapter 209 of Texas Property Code and related Texas and federal law may be made at any regular meeting of the Board of Directors by a majority vote of the directors, the proposed amendments having been submitted in writing. The bylaws and amendments shall be filed with the district clerk, King County, Texas. This is an addition. Placed in the principal office and updated on the association's website no later than 5 business days after the annual election or the regular meeting of the Board of Directors. A couple of things. Dustin had a suggestion. We talked about this. No one's offended by members wanting to vote on the bylaws. However, they're correct in that changes in the bylaws required because of change in the law must be handled in an expeditious manner, and the board must have the ability to do that. If members objected to a change in the bylaws because the law required it, their vote would be meaningless because the law requires it. And if any of you were here years ago when the Omnibus 209 was passed and we had an attorney sit here to explain what we could not do under the new law, people argued with him that we should have a right not to follow the law if we didn't like it. So, that's not the case, folks. And the second part, it's required by law that we file with the county, so it doesn't need to be in the bylaws. And the filing period of 5 days is not sufficient, because once it's passed by the bylaws, whether it's done during the year because of a law change, or it's agreed that the members can approve other parts of bylaws, 5 days is enough, because a final version has to be typed up, notarized, signatures from the board of director, and taken over to the courthouse if and when it's open around COVID. So having a 5 business day filing, we would probably violate that almost every time it was done. So, and it doesn't really need to be there, because the law requires that we file it with the county. So, any other comments on any of this from? Okay, this is what we came up with. So, any other tweaks from the election committee? If you'll get those to us, then perhaps sometime between now, because we want to get this written up for the January meeting. And we also want to be able to get it written up and copies of the changes left at administration desk so you can pick them up, because it's too large a document to just put on dispatch. To pick up and review, fine. We need to start working on that, so if you gave those to us, then I'll...
Can I make one comment?
Yes, you're on the committee, sir.
Yes. I will present to the bylaws committee the issue of the tweaking and whatever clarifications need to be made. The goal of the bylaws committee is to get this on the ballot. I know at this time you all have the authority to make those changes, but we prefer that the membership be given the opportunity to vote on these changes. That is the objective, that is the goal. Thank you.
Thank you. So if you can get those to, if you can leave them up at admin, directing them to Julie.
Yeah.
She's kind of our paper coordinator. She's our document coordinator.
Gotcha.
So I guess what we're doing, we're saying that we're motioning to table this until we get a final draft. I mean, because we had that discussion with Linda, but I don't know if you guys want to still keep it exactly the way that it is after we have the recommendations. I mean, this may be a final copy, but we just need to have the final one for us to vote whether or not we're going to do it.
At this moment, I recall there was 1 or 2 things that came out of Monday's meeting that we want to change. That would make it a little bit simpler. So we will get together. Matter of fact, here's the man of the hour, Paris. That is the goal.
Okay.
And then hopefully we'll get those to you as soon as possible.
Okay, and then you only need to put the changes highlighted in red without the removal part, because we want the members to be able to look at what it's going to read, how it's going to read. Do you understand what I mean?
Yeah.
That gets confusing when you have the line crossed out.
For clarification, once we submit it to you, you're all going to decide whether it's going to go on the ballot or not? Or it's going to go on the
You can
ballot?
request that we put it on the ballot.
Yeah,
It may be certain things that, it's possible that we may authorize certain changes and put only certain changes on the ballot, okay? Depending on what these are. Because, for instance, the alternate one violates our declaration. We can't put that in the bylaws. So,
Well, maybe we better consider a baby workshop before then, just for your all sake and our sake, but that's fine.
well, we can do that. We can consider a workshop with the committee and with the board and with Alan and Julie, and then have the members can sit in out there and just listen.
Perfect.
So we'll talk about that.
That seems very reasonable.
Okay,
Thank you.
thanks, Lynn. Okay, we want to table this until we receive the further tweakings from the bylaw committee. We have a motion?
I motion we table.
Second.
Okay. All in favor? Okay, we're going to table this until we get the tweaks, changes, recommended changes. Okay, couple of announcements. Our Christmas hours will be posted. Yeah.
No, I don't have them yet. We'll be posted.
Okay, the Christmas hours will be posted on the dispatch. Will be posted on the dispatch. Again, a reminder of the 2 movies that are coming up. I mean, please be smart when it comes to the CDC guidelines. We don't want a mini spreader event here on the fort. Obviously, a lot of us are over 60. And we prefer not to spend our Christmas in the hospital. Okay. All right, we are going to adjourn to executive session. We have a couple member and employee issues to discuss. So it is 10:41. We are adjourned to executive session.
Hi, how are you?
Oh, really? And she wants to be on. Oh, wonderful. Yeah.